Hello everyone, welcome back to the Let's Dream Civils YouTube channel. Today's topic of discussion is sedition, section 124A of Indian Penal Code. This topic has gained importance after Supreme Court's revival of section 124A proceedings, which was put on hold in the year 2022. So this revival raised a fundamental constitutional question about how should a democracy balance civil liberties and the state security. Now let's look into the context of the May 2026 sedition clarification. In the case Kamran versus State of Madhya Pradesh, a division bench of the Supreme Court clarified that lower courts may proceed with the trials and appeals involving Section 124A of the Indian Penal Code if the accused offers explicit and informed consent. This triggered the concerns over a colonial law the country did not want. Because in the year 2022, the same Supreme Court, for the same reason, has placed the sedition in complete abeyance and also directed the union government and state government to refrain from registering any fresh FIRs and also halted the pending trials and appeals under this section 124A. But now, why there is a need for this revival? Because many accused facing sedition charges are locked in multi-charge cases such as EAPA, Arms Act, and all. And also, they face prolonged detention as after the 2022 order, thousands of cases were frozen. Imagine a person was charged under sedition, section 124A in the year 2018, but after the 2022 freeze, there is no trial, there is no judgment, and there is no closure for their cases. So, this order aims to protect the speedy trial, right? Allowing individuals to seek final deliverance from a criminal charge through court's verdict. Now, let's look into the anatomy of section 124A. And also, first, let's see the historical origin of the sedition. The idea first appeared in the draft penal code provided by the Thomas Bevington Macaulay in the year 1837. But it was omitted from the original Indian Penal Code enacted in the year 1830, but later it was inserted in the year 1870 via section 124A by James Fitzjames Stephen. This is one of the harsh sanctions in the Indian Penal Code because this classifies sedition as a non bailable cognizable offense and the punishments range from 3 years to life imprisonment. This sedition was specifically introduced into Indian Penal Code to silence the political opposition, crush nationalist movements, and also control nationalist media. The legal definition. The sedition is defined as an offense committed when any person by words, spoken or written, through signs or through visible representation brings or attempts to bring any hatred or contempt or excites disaffection towards the government established by law in India. So this section explained disaffection as a disloyalty and all feelings of enmity. So this was extremely broad. The law never clearly defined how much criticism becomes disaffection towards the government. So this vagueness became the biggest constitutional problem. The historical trials and the colonial silencing. Bal Gangadhar Tilak in the year 1897 and 1908. So Bal Gangadhar Tilak was tried 3 times under Section 124A for his critical writing against British policies in his weekly newspaper Kesari. And also, Justice Arthur Strachey interpreted disaffection as an absence of affection, effectively criminalizing any lack of active devotion to the British crown. Again, complete vagueness and a very broader definition. So, and also, Tilak's conviction and subsequent deportation to Mandalay jail made Section 124 a symbol of colonial oppression. And then Mahatma Gandhi in the 1922 trial. Gandhi was prosecuted for articles published in Young India along with the publisher Shankarlal Bankar. Gandhi famously termed this Section 124A as a prince among the political sections of Indian Penal Code designed to suppress the liberty of the citizen. Gandhi also argued that Affection cannot be manufactured by law. And also, if one has no affection towards the government, one should have the liberty to express it fully. The constitutional conflict. The sedition law, the sedition 124A of Indian Penal Code, contradicts the freedom of expression provided by Article 19, because Article 19, Clause 1, Subclause A guarantees every Indian citizen the fundamental right to freedom of speech and expression. Criticizing the people in power is a vital component of a functional democracy. But this power is not absolute power, because Article 19, Class 2 allows limits on speech based on sovereignty and integrity of India, security of the state, public order, and incitement to an offense. Only to protect these, they have allowed for limits on speech. Otherwise, every Indian citizen has the right to freedom of speech and expression. The critical jurisprudence argues that mere disaffection or any non violent political criticism does not threaten the security of the state. And also, this sedition contradicts with Article 14 and 21. Article 14 provides equality before law, allowing some individuals to be tried under Section 124A based on the consent provided by them, while others remain past, creates a procedural inequality which contradicts with the equality before law. And also, the threat of life imprisonment under a vague, broad definition colonial era statute violates the principle of procedure established by law. This contradicts the Article 21, the fundamental right to personal liberty. The previous judicial landmarks on sedition. In the year 1959, in Ram Nandan case, the Allahabad High Court declared Section 124A as unconstitutional and also stated that it placed an unreasonable restriction on the free speech. In the year 1962, Kedar case, a 5-judge Supreme Court bench upheld Section 124A, but they narrowed its scope strictly to incitement to violence or public disorder. 1995, Balwant Singh case. The Supreme Court ruled that raising casual anti-national slogans a few times without inciting actual violence does not equal sedition. From Section 124A to Section 152 BNS. So we all know in the year 2023, the Indian Penal Code was replaced by Bharatiya Nyaya Sanhita. So now the new law is BNS Section 152. While the Bharatiya Nyaya Sanhita deleted the specific term sedition to mark a shift away from a colonial era legal code, it introduced Section 152 under the chapter Offences Against the State. But it broadly expanded the scope. It criminalizes any act that excites or attempts to excite separation, armed rebellion, or subversive activity. It shifted the legal focus from protecting the temporary government established by law, as defined in 124A, to protecting the sovereignty, unity, and integrity of India. But still, the critics note that terms like subversive activities remain undefined. Here also, it is not clearly defined, so it carries similar potential for administrative misuse. Thank you everyone for watching. If you find this video helpful, kindly subscribe to the channel for more such informative videos. Thank you. Stay tuned.